in summary, our powers at the moment are not just monetary penalties. We have for a long time had the power of criminal prosecution. There are some criminal offences in the Data Protection Act. There's still the offence of not being registered, not being notified to us, and we still do prosecute for that. But perhaps more importantly, there's the Section 55 offences under the Data Protection Act. The offences of knowingly or recklessly obtaining or disclosing personal data without the consent of the data controller, what are commonly called the blagging offences, the things that featured in the Leveson inquiry where journalists or private investigators are obtaining information by deception. The most recent case we prosecuted just a few weeks ago, a receptionist in a GP's surgery who was accessing the GP records, looking for information about the new wife of her former husband, and was using that information essentially to cause trouble, and a fine there of £750. It's an area where we are still pushing for prison sentences to be available as an option, not in cases like that, but for those who are engaging in this as a major business. And we are confident that as part of Leveson's proposals, and when the government has consulted on those, which we expect to happen fairly soon, one of the things they will be consulting on is Leveson's suggestion, along with many other people's suggestions, that there should be prison sentences available. And we are keeping our fingers crossed this time that, perhaps by this time next year, we will actually be able to come here and say that there are prison sentences available. We have enforcement notices, which are notices which require a business to change its practice, to change the way it operates. The most recent example of that is enforcement against Google. This is the payload data disks when the Street View cars were operating and they were collecting Wi-Fi information. The information that they collected there, where Google gave us an assurance that those disks had been deleted, and then several months later came along and said, well, despite the assurance we gave you, the undertaking we've given you, we have found some further disks. So we have translated that into an enforcement notice, which basically says, well, if you haven't actually deleted them all now, you're under a criminal offence if that hasn't worked. A criminal offence not to comply. Formal undertakings which we use, which are not part of the statutory process. There's nothing in the Data Protection Act that refers to them, but notices that an organisation signs which gives us a promise to take action. And we accept that where we're confident that the organisation will do as it's promised. It's signed by the chief executive or someone at a very senior level, and usually it delivers results. So many of the data breaches that reported to us don't result in fines, they don't result in enforcement notices, but they do result in undertakings where we get an assurance, a published assurance on our website from the organisation that it will take steps to make sure the breach doesn't happen again. But then the area where the most interest is the civil monetary penalties, the fines. We've had something like getting on for 40 under the Data Protection Act since this power came in 3 years ago. Most recently, Glasgow City Council was fined £150,000 for, believe it or not, we're still on unencrypted laptops, albeit that they had a program for encrypting laptops, but not one that was effective enough to ensure that all laptops were encrypted. And more recently, for just about a year now, those civil monetary penalty powers have been extended to breaches of the privacy and electronic communications regulations. So the sending of spam without consent, or the making of unsolicited marketing phone calls to people who've objected on the telephone preference service, those can attract monetary penalties, fines now. And the most recent ones were against a company called We Claim You Gain and its sister company Nationwide Energy Services, which you may better know from the BBC Three programme, The Call Centre. and I can't remember the name of the sort of boss there, but David Brent looks positively sort of mild by comparison with him. I have to say it's entirely a coincidence that this program, the call center, was on at the same time that we were developing and actually served these notices. We had no idea about it. But those essentially are our powers as they stand at the moment. And they're not exclusive. You know, I mentioned Glasgow City Council. They were both fined for not having a proper encryption process in place, but also issued with an enforcement notice to require, under criminal penalty, changes for the future, because we weren't confident that the fine alone would deliver the necessary change for the future.